Thank you all. It's a great pleasure to be here, and I'm especially grateful for the wonderful work that Americans United for Life does year in and year out. This 40th anniversary of Roe is, for me, a poignant and somber date. I moved to Washington, D.C. Some 21.5 years ago to be a law clerk for Justice Scalia. I was a law clerk during the term that Planned Parenthood v. Casey was decided. The opportunity that the court had to set things right, and it flubbed it tremendously, and we're still paying the consequences. So it's it's amazing to me to realize that here we are 20 years after that, we still haven't gotten it right. But we, of course, know what is legally and morally right, and will continue to fight no matter what and prove wrong the court's strange belief in Planned Parenthood v. Casey that it was somehow calling the contending sides to give up the fight and to respect the court's illegitimate decision. Now, I would like to address the intellectual bankruptcy of Roe and Planned Parenthood v. Casey, and I'm afraid I may be repeating some of what Jerry Bradley had to say, including perhaps some of his jokes. I came in midstream, so my apologies if there is some repetition, though. I would like to think that when people are speaking right, it's natural that they reinforce each other. And of course, my bottom line point is it's well past time for all Americans, no matter what their views on abortion policy, to recognize that the abortion regime imposed by the Supreme Court in Roe and maintained in Casey should be dismantled. Now, Roe versus Wade is a frightening and lousy opinion. It borders on the indefensible. It's a verbal smokescreen. It provides essentially no reasoning in support of its holding. Those are not my characterizations. Those are not the characterizations of pro-life critics of Roe. Each of those statements and more are criticisms that supporters of abortion have offered of Roe versus Wade. But even these criticisms do not adequately explain why we're here today addressing a case that the Supreme Court decided 40 years ago, that it ratified 21 years ago, and that America's cultural elites embrace. The broader explanation I would submit is twofold. First, Roe versus Wade marks the second time in American history that the Supreme Court has blatantly distorted the Constitution to deny American citizens the authority to protect the basic rights of an entire class of human beings. The first time, of course, as Clark Forsyth mentioned, was the court's infamous 1857 decision in Dred Scott. There, the court held that the Missouri Compromise, which prohibited slavery in the northern portion of the Louisiana territories, could not constitutionally be applied to persons who brought their slaves into free territory. By its ruling, the court cast aside the efforts of the people through their representatives to resolve politically and peacefully the greatest moral issue of their age, and it made all the more inevitable the Civil War that erupted 4 years later. Roe is a Dred Scott of our age. Like few other Supreme Court cases in our nation's history, it is not merely patently wrong, but fundamentally hostile to core precepts of American government and citizenship. Roe is, simply put, a lawless power grab by the Supreme Court, an unconstitutional act of aggression by the court against the legislative powers of the American people. Roe prevents all Americans from working together through an ongoing process of peaceful and vigorous persuasion to settle our abortion policies and revise them as we see fit in our 50 states. Roe imposes on all Americans a radical regime of unrestricted abortion for any reason, all the way up to viability, and again, as Clark mentioned, under the predominant reading, though I think not necessarily the correct reading, of Roe's companion case, Doe versus Bolton, essentially unrestricted even in the period from viability until birth. And of course, Roe fuels endless litigation in which pro-abortion extremists challenge modest abortion-related measures that state legislators have enacted and that are overwhelmingly favored by the public. Provisions, for example, seeking to ensure informed consent and parental involvement for minors, and barring atrocities like partial birth abortion. Roe disenfranchises the millions and millions of patriotic American citizens who believe that the self-evident truth proclaimed in the Declaration of Independence, that all men, all human beings, are created equal and are endowed by their Creator with an unalienable right to life, warrant significant governmental protection of the lives of unborn human beings. Now, I heard, or at least read, I didn't actually watch it, President Obama cite the Declaration the other day in his second inaugural, but he clearly does not believe that passage, and I think the rest of it is, of his speech is equally designed to move away from the Declaration rather than adhere to it. Now, so long as Americans remain Americans, so long that is as they remain faithful to the founding principles of this country, they will never accept Roe. Now, of course, I think it's fair to say now it's a big question whether Americans will remain faithful to our founding principles, and certainly you see that that the judges move further away. I think it would have been unbelievable 20 years ago to imagine that the Supreme Court might be on the verge of imposing a radical redefinition of marriage on the country. Yet many people, counting noses, expect that to happen by the end of June of this month. Of course, the second reason to explore Roe, to re-examine it, is the ongoing confusion that somehow surrounds the decision. Again, as Clark mentioned, leading political and media figures deliberately or otherwise routinely misrepresent and understate the radical nature of the abortion regime that the court imposed in Roe. You often still hear somehow, 40 years after the opinion, that Roe merely created a constitutional right during the first 3 months of pregnancy. There's nothing in Roe or Planned Parenthood v. Casey that can be intelligibly misread to support such a proposition. And of course, a more elementary confusion is reflected in the commonplace assertion that Roe legalized abortion. The court did not merely legalize abortion, it constitutionalized abortion. In other words, the American people had the constitutional authority before Roe to make abortion policy, and Roe deprived the American people of this authority. And I think that assertion that Roe legalized abortion bears on the surprisingly widespread misunderstanding that many people have of what the effect of a reversal of Roe would be. Again, Clark referred to this. I won't go further into it, but you have this strange disconnect in the polling on abortion, where I think largely because of the misunderstanding of Roe, there's a majority that favors preserving Roe. But when you look at the actual policies I'd like to see enacted, an overwhelming majority wants things enacted that can't be enacted so long as Roe exists. Now, let me turn to Planned Parenthood v. Casey, which I think in many ways is an even more appalling decision, if that's possible to say, than Roe, at least in some respect. I mean, the Planned Parenthood v. Casey is so breathtaking in its grandiose misunderstanding of the court's role that makes one long for the sterile incoherence of Roe. I'm sure, I gather I was coming in just after Jerry had mentioned this infamous passage in Casey. At the heart of liberty is the right to define one's own concept of existence, of meaning, of the universe, and of the mystery of human life. This provision is at the core of Planned Parenthood v. Casey. Now, we used to have a word for someone who believed that he had free rein to define his own concept of existence, of meaning, of the universe, and the mystery of human life. That word is lunatic. It's a classic definition of what a lunatic is. Yet we have 5 justices on the Supreme Court embracing this proposition. Of course, the provision itself is incoherent. If I would like to define my own concept of meaning and of existence, of living in a country in which I didn't have a Supreme Court that spewed such gibberish, I couldn't do it. So, of course, this was a shell game for the court to conceal its own continued power grab. And we likewise see in that opinion more wordplay designed to camouflage what the court was doing. This notion that the majority isn't going to give in to pressures from those who want to see Roe overturned, as though there weren't far greater pressures in their own social circles to retain Roe. In any event, the court shouldn't be deciding what the Constitution means based on political pressures. It ought to be just getting it right. But of course, the court in Planned Parenthood v. Casey didn't even go so far, didn't even claim that Roe was right. Instead, under its confused notion of stare decisis, it thought it necessary to adhere to it, even if it was wrong, in order somehow to maintain the nation's confidence in the court as some sort of Nietzschean leader of our ideals. I encourage you sometime to read, if you haven't done so recently, Justice Scalia's dissent in that case, which I think is masterful, and that's, I emphasize, I have to take zero credit for it. Now, where are we now? Well, I, perhaps temperamentally, if I'm rarely accused of being an optimist, I'm not going to be an optimist now. The fact of the matter is we fight this fight not because we expect to win it in a particular time, but because we know it is the right fight. We know that we fight this for our kids and grandkids. We fight this to restore a country that's worth, that lives up to American ideals and that's worthy of those. We've had a couple big setbacks in recent years. I'm speaking of the confirmations of Sonia Sotomayor and Elena Kagan. What you had is 2 seats on the Supreme Court that were held in pro-abortion hands that presented huge opportunities for marginal improvement on the court. And those are entrenched in pro-abortion hands, presumably for another 25 or 30 years. The court right now, it's fair to say at best, has a 5-justice, at best from a pro-life perspective, at best it's 5-4 against us, with Justice Kennedy and the 4 Democratic appointees. We know we have 2 justices who have made clear their willingness to overturn Roe, and 2 others, Chief Justice Roberts and Justice Alito, who have yet to have occasion to make clear their views on that fundamental question. We may well see another 1 or 2 Supreme Court vacancies during this second term of President Obama. If Justice Ginsburg is replaced, the status quo will be maintained, but worse, entrenched for her seat would be entrenched on the wrong side for another couple decades. If we God forbid, see a Justice Scalia or Justice Thomas step down, there's an opportunity for a dramatic swing, making the court even worse, not just on this issue, but a host of others. So, you know, I think pro-lifers were alert to this and active in the presidential election in 2012. Obviously, we need to hope that in 2016 we can turn things around and make dramatic improvement. So with that, I think I will hand things off to Helen Alvarez. Thank you.